Welcome and happy Friday, everyone. My name is Lalita, and I'm the coordinator of EMCoP, which stands for the Emerging Media Community of Practice. Thank you for joining us, whether you're here live or you're watching the recording. We appreciate you being here and our esteemed presenters sharing their expertise with us. They will talk about legal developments in artificial intelligence, and there will be time for some Q&A throughout, as well as at the end. Our presenters have a lot of knowledge and experience, so please get your questions ready. As we begin, we would like to acknowledge the Indigenous peoples of all the lands that we're on today. The UBC Vancouver campus is located on the traditional, ancestral, unceded territory of the Musqueam people. And since we're meeting on a virtual platform, please join us by acknowledging the importance of the lands we call home. In the chat, please let us know where you're joining us from. And we're curious, have you ever attended an EMCoP online event before, or is this your first one? I'm going to do just a little brief snippet about EML and EMCoP at UBC, and then some housekeeping, and then we'll get right into things. So the Emerging Media Lab, which is EML, is at UBC and was the initiator and is the caretaker of EMCoP. So UBC is the host of these events, and they happen every 2 months or so. We make these online so that they're accessible to people outside the Lower Mainland. A community of practice is a group of people who come together because they have a similar interest, yet have diverse perspectives and expertise and roles within the community. So it's very much about bridging these communities, whether you're from academia, the industry, the public, and bringing people together to communicate about things that we find interesting and important. The Emerging Media Community of Practice at UBC is a collaborative group of researchers, developers, designers, educators who are volunteering, and because they're committed to building a community of practice focused on the development of emerging media technologies for the human good. So we've been focusing this year on AI, but we talk about emerging media technologies in general as well. Housekeeping, so many of us know and have used Zoom, but just reminders that we have the chat versus the Q&A. The chat, we welcome you to and invite you to keep conversations going, meet other people, say a little bit about yourself, you know, like what brings you here today? Why are you interested in artificial intelligence and the law? Maybe a bit about your demographics. You know, are you a student, a professor in the industry? Just share a little bit. Feel free to let us know who you are and why you're here. Our usual event structure is to have 3 speakers. One of our speakers, unfortunately, is feeling unwell. Dr. Martin Barreteau will not be here, and so we wish him a speedy recovery, and we'll hope to reschedule him for some time in the future. Our first presenter will be Dr. Céline Castet-Renard. She is a full professor at the University of Ottawa in the Civil Law faculty. She holds several research chairs, Accountable AI in a Global Context and Accountability and Social Trust in AI. She's an expert on comparative personal data protection and privacy, platform regulation, technologies of surveillance and cybersecurity, and her research aims to take account of social justice issues. So her list of affiliations and memberships and accomplishments is very long, so please read her bio. You can access her more information and her publications from the EMCoP website, which is simply emcop.ca. And my understanding is Dr. Céline Castet-Renard is going to talk about regulatory approaches in Canada and the EU. And this will also expand into generative AI. And so thank you so much for being here, Dr. Castet-Renard, and I hand it over to you.
Thank you, Lalita. Thank you, everyone, for being here, and thank you for inviting me. It's a great pleasure and honor to share my thoughts today with all of you. And I'm going to try to present the EU regulation on AI. This is a proposal for the moment. And the proposal of Canada, which is Bill C-27. And as Lalita mentioned it, after that, I think I will have a conversation with John on generative AI in particular. I have some slides to share, so I'm going to do that right now. It won't be long. Okay. So I propose to present very broadly the regulatory approaches in Canada and the EU, and seeing the differences between both countries or both parts of the world. And maybe we could have a conversation about the pros and cons of these two different approaches. And I think one of the things very interesting here is the fact that even if the approaches are different, and it is different because the way of making laws are different, but on the other hand, we can also see that there are convergence, substantial convergence regarding the provisions, the rules we should take on AI. Just to be sure to be on the same page, to be sure that everybody would be on the same page, I just want to give a very broad definition of AI and artificial intelligence system. It means a machine-based system that is designated to operate with varying levels of autonomy. Autonomy is very important here, even if it's partly autonomous or entirely autonomous, it doesn't matter, but autonomy is important, with explicit or implicit objectives. And these systems have cognitive functions. I think this is also a second point very important regarding the definition of AI. And the four main cognitive functions we could see today, maybe we will see other in the future, we never know. But for the moment, we can see four cognitive functions. These AI systems can predict, make recommendation, make decision, or helping for decision making, and can generate content. And we talk about generative AI. And when we talk about content, this is very broad. It could be text, images, video, music, coding, computer coding, and computer code, and so on. So because there are these cognitive functions, we can understand that human and machine have different parts in the real life today, especially when this AI system are employed for the social life, for instance, for prediction in medicine, or for making decision making in administrative procedure, to obtain a loan, and so on. This is because these systems are used very in the daily life, that we have a lot of questions about the role of AI and the role of human. And there is a new field of research, which is the interaction between human and AI, and we have to figure out how this interaction can work correctly. And we also understand that because these AI systems are used in the daily life and in the social life, as I mentioned, for medicine, for credit scoring, for making decisions on social advantages, and so on. We can also see social and ethical issues on AI, and of course legal issues, because these AI systems are very complex. We talk about deep learning, machine learning, and we also talk about foundational models or general purpose AI systems. So it's very opaque, complex, unpredictable. Even if we can we assign some goals to these systems, they also have their own goals sometimes, and they can and they decide the way to attain their goals. This is a part of autonomy. We also know that AI systems functions with data, and they need a lot of data, massive data. And we also know that we can have some issues with the quality or quantity of data, and we could have issues regarding the representativity of data, especially when the data are supposed to represent the society. We need to have all the representation of society, but most of the time we can see the biases in data. And if we have biases on data, we also have biases on AI systems. There is a very simple expression, garbage in, garbage out. And because of all this complexity and specificities of AI systems, we can understand the social issues and the legal issues regarding safety risk, fundamental rights, enforcement, of course, and also the problem of mistrust. And even if we talk about responsible AI, trustworthy AI, we need to find a way to build this trust. And the literature, there is a very broad literature on these social issues and the problem of racism, of biases on gender, on economic factors, and so on. So we know the problems, and that's the reason why the law can have a role to play in order to minimize the risk, the social risk, ethical risk, and in order to find a way to build this trust on AI and to build a true responsible AI. That's the reason why the first step was the European Commission, which was the first lawyer, the first legislator worldwide to build a first framework on AI. And this draft has been released in April 2021. So there is more 2 years ago, 2 years and a half. It takes time to adopt an EU legislation because you need to have the proposal from the Commission, then the version of the Council, and then the version of the European Parliament. So there are 3 institutions, and now we had this agreement with the 3 institutions, but in 3 different texts. And currently, this AI Act is not yet enacted, but should be enacted at the end of this year, because these 3 institutions are in trialogue, and they try to find a compromise to have the same text, the same bill on AI regulation. But that's the reason why I cannot enter into all the details, because all the details are not yet known, because there is still this negotiation, and the text is not yet fixed, is not yet final. But we can have a discussion about the approach and the way the European Commission tried to build this AI regulation. And the first important thing to know is the European approach is a risk-based approach. And the European Commission creates a distinction between 4 categories regarding the risk. And the risk can be unacceptable, high, low, or minimal. And if the risks are unacceptable, it means the AI system cannot be developed within the European markets. If the risks are high, they can be developed, but there are some specific provisions to fulfill, some requirements to fulfill. And if the risks are only low, there is only a mention of transparency, meaning there is only an obligation to mention the fact that let's say, for instance, the video, the image has been made by AI. And when we talk about risk here, it means risk regarding the health, the safety, and fundamental rights. So it's very clear when we see the risk. And there is also something very clear in the regulation, in the EU regulation. This is about the different kind of unacceptable risk and high risk systems, because these systems are listed. There is a limited list and concrete use cases of risk, which are considered than unacceptable and high risk. Regarding unacceptable risk, for the moment, we have 4 categories of unacceptable risk, meaning the AI system won't be developed within the EU. These risks are about subliminal manipulation of AI systems, exploitation vulnerable groups such as children or disabled persons, general purpose social scoring by public authorities, real-time remote biometric identification, meaning such as I forgot the word in French and in English. Sorry, it will restart later. It will come back later. Remote biometric identification in publicly accessible spaces, and with for law enforcement, with 3 exceptions. But I have to mention that even if these categories are very clear, these use cases are clear, because it's still an ongoing process, and because the EU regulation is not yet enacted, these unacceptable risks are not yet completed now. So we still have discussions about these cases, and probably we will have more than that. And probably some high risk could become unacceptable risk when we will have the final version of the text. So which we have to be very careful here, because we don't really know if that will be the final version. And this is the same regarding high-risk AI systems. We also have a list. This list is in the Annex 3 of the text of the AI Act. And as you can see, we have 8 categories of 8 domains, 8 use cases regarding AI systems on biometric identification, management and operation of critical infrastructure, education, employment, essential private services and public services and benefits, law enforcement, migration, and administration of justice. But once again, we still have some modification of this part of the text. And currently, this week, there was a technical meeting specifically to discuss this list of high-risk system. But anyway, even if this list is not the final one, you can have an idea about the kind of system which could be considered as AI system. But more important here, you can understand that the EU really would like to precise and to give the details of the list of AI systems. There is no general definition of AI system. There is no general criteria or factor to identify AI high impact, high risk AI systems, but a list. And if the system is not in the list of high risk system, it means it's not risky. It's not so risky. And it means the requirements, the specific provision regarding high risk system won't apply for the other AI systems. So there is a pros and cons with these systems, because it's very clear, it's very safe and secure. There is a legal certainty, which is very important for lawyers and for people. But on the other hand, this is very, if the system is very well precise, there is no way for evolving, and there is no way to take into account new systems, new AI systems, if it's not precise and details in the text. Of course, there is a way to change the text, and there is a specific role for the European Commission to do it, but we can see that it will take a bit of time to evolve and to take into account new AI systems. And just to give you an overview of the kind of requirements regarding high-risk AI systems, you can see that this kind of system has to have high-quality training, validation, and testing data system. They also have to, the providers of this kind of high-risk AI system have to establish a technical documentation, transparency and information, a human oversight, and have to guarantee, have to ensure robustness, accuracy, and cybersecurity measures. And all this, I don't give you the details, but all these requirements are precise with details in the EU text. Just to give you an idea, the text is more 100 pages, so you have all the details. And on the other hand, we also have a bill in Canada, Bill C-27, and this bill is about data protection, personal data protection, and about artificial intelligence. There are three parts in this bill. Part 1 and 2 are on data protection, privacy and privacy provisions, and part 3 is about ADA, Artificial Intelligence and Data Act. And I'm going to focus on this part 3. And in this part 3, the scope of the regulation is not so broad in comparison with the EU. The scope in the EU is broad because the AI Act will apply for all the AI systems used in the European market. So even if the providers of AI systems are outside of the EU, if the AI system is used in the EU, within the EU, the AI Act will apply. In comparison here, the AI system concerned by the text concern only the AI systems used by companies, and this act, this Bill C-27, does not apply to a governmental institutions. So this is a very important limit here. The scope is limited to companies, and only companies who has a link with the regulation with the international and interprovincial trade and commerce. And it means that it concerns only AI. It focus on only AI systems used for international, within the context of international and interprovincial trade and commerce. We can understand here the question of sharing of jurisdiction and the question of competencies of jurisdiction. And the province have jurisdiction for intra-provincial trade and commerce. That's the reason why the Bill C-27 doesn't apply to this kind of commerce and trade. This is a very important limit here. The scope and purposes are limited. And also we can see that the purpose of Bill C-27 is to focus on harms and serious harms. But we will see that there is very few information about the kind of system which are concerned by which are within the scope of Bill C-27. And if I go forward, we can, as I mentioned now, as I just mentioned, high impact system, the Bill C-27 will apply only to high impact systems. But we have no definition of this, and this is a very important limit here. And this high impact systems is about, the goal here is to regulate high impact system, which generates a risk of harm and biases. So we are focused on harm and biases, and harm are very individual harms because it concerns physical, psychological harm, damage to property, economic loss to an individual. But we don't consider here more collective harms, more global harms, for instance, for cultural diversity, for instance. And we can understand here that maybe some human rights won't be considered if we have a very closed eye on the definition of harm. And the second risk to consider, which is regulated here, is biased and biased outputs. And we have a link here between this regulation and Section 3 of the Canadian Human Rights Act, and especially the risk of discrimination. I think this is very interesting here to have this link and to have a more specific definition of discrimination. But once again, some other human rights could have been harmed, and there is a doubt or a risk that this kind of harms or won't enter into the scope of the regulation of the bill. I think here, regarding the person responsible, just to give a comparison with the EU law. In the EU law, the main person who is responsible is a provider of the AI system, and here we have a more broader. We have also obligation for a distributor, importer, and also a deployer. But here we have some different person, the person who design, develop, and make available the artificial intelligence system. And I think this broad definition is very interesting. And this person has three main obligation. They have to assess their AI system, and they have to check if there is a high impact, a risk of high impact, a risk of harm or discrimination. They have to identify this risk and mitigate them, and they have to monitor their measures to be sure that this measure can really mitigate the risk. And if all these provisions are not respected, there are criminal offenses which are very, very high. And I didn't mention it for the EU, but that's the same. And the sanctions are also very very high in case of violation of the AI Act. And regarding the BC27, I have to say that there are a lot of debates, and I'm sure we will have a great conversation after that. A lot of debates about this bill, because as I mentioned it, there is a vague, there are some vague provisions. There is no definition of keywords such as high impact, and there is not enough provisions on obligation for the to the operators. Also, we have some provisions, some very bureaucratic oversight and criminal sanctions, which seems very heavy and maybe not very well adapted to this this kind of economy, the digital economy and innovative economy. And more important, there are a lot of provisions under the authority of ICET, and especially of the Minister of Innovation, Science and Industry, or designated officials. And for instance, there is a commissioner on data and AI, but this commissioner is not independent, but related to the minister. So as you can imagine, there are a lot of critics here regarding this governance measures. But on the other hand, we can also see that the government and the Minister of Innovation, Minister Champagne, had this ministry had released another document, a companion document, which gave more information about regulations and about the agile approach that they would like to have. And Bill C27 creates some a lot of room for regulations, and this regulation would be taken by the Ministry of Innovation. But the companion document gives more information regarding the kind of criteria or factor which could be used and which could help us to understand Bill C27. For instance, we have some criteria regarding the notion of high impact systems. This notion would be defined in regulation, but we have, for instance, a criteria of evidence of risk of harm to health and safety and the risk of adverse impact on human rights. So as you can see, we can see health, safety, and human rights, which are the domain of the risk in the EU regulation. So maybe in the EU framework, maybe it means that in the implementation of Bill C27, maybe we will have more convergence between both EU and Canada regarding AI systems and the risk created by these systems. And now we understand that Part 3 regarding AI and Data Act standalone and would be separated to the other parts of Bill C27 on data protection. And we also see that we had a public consultation in next month regarding a code of practice for generative AI systems. Generative AI systems are the new concern today, and Canada would like to create a code of practice. And on the other hand, the EU would like to integrate generative AI in the AI Act And I stop here, and I will give you more information regarding generative AI in EU law after John's presentation. Thank you for your attention.
Thank you so much. If anyone has any questions, I do have one from John. And he asked, is there existing legislation that governs the use of AI systems by governments in Canada?
In Canada or in the EU? Yes, in Canada.
Canada.
There is a directive from the Treasury Board, directive regarding AI system used by the agencies, federal agencies, but this directive is not mandatory, but very well known, but there is a grandfather clause. It means this directive applied only for the future, not for the past. But there is a directive, yes.
Okay, and sorry, just to clarify, that was John Mills. John, if you have anything else you want to just add to your question, feel free. Thank you for that initial presentation. We're going to switch over to John for a moment, and then because we're down to 2 presenters, we actually have more time to possibly go more in depth and also to direct. We have 2 experts here, so if there's anything you want to ask at all, now's the time. I will just introduce John Festinger, KC. Sorry, did I mispronounce that? You'll have to correct me if I did. My apologies. He is a Vancouver-based lawyer at Whiteboard Law. He's an educator in many capacities. At the University of British Columbia, he's with the Allard School of Law, the Media Studies program, and the Graduate School of Journalism. He's also a professor of professional practice at Simon Fraser University. He's a faculty member of the Center for Digital Media. And my understanding is he has a special interest in AI with respect to creativity and copyright. Now, John's list of accomplishments are also extensive, so please read more about him and his publications from the EMCoP website. And I'll leave it at that, and over to you, John.
Hey, let me just ask whether you can see my slides.
Not yet.
Not yet. All right. Well, that's sort of the interesting.
Are you able to share your screen?
I am able to share my screen, and let's see. Can you see my slides now?
Yes.
Perfect. All right. Amazing presentation by Celine. So many things we can go through. I unfortunately start teaching. I have to leave at 1:15 PST because I'm teaching at 1:30, but I am in the law school, so I just have to leave my office and go downstairs. So things may go on without me. I'm going to take a slightly different tack on all of this. I will deal generally with kind of where we are in the digital world. I'm probably going to go a little more into copyright first, and then I'm going to talk about the harms in an indirect way. But my main perspective, because I think we are generally in EMCoP among educators, I'm going to be talking through an educational lens. One thing I noted from Celine's presentation that I think we should all underline in our minds is that at least in the EU, I'm not sure, Celine, where this stands in Canada, education is seen as a high-risk category. So how we approach AI has potential regulatory and legal consequences for our institutions. We really want to be thinking about that as we go through things. My perspective, Celine gave a great definition of what AI is. I look at our times generally, and I say we are looking at life through a digital lens. The law, particularly copyright law, was developed hundreds of years ago, and doesn't always change with the times or technology with immediacy. It does inevitably change. I have a great deal of faith in law, and I have a reasonable amount of faith in regulation. Not everybody does, but law is not immediate in its changes. There are reasons for that I think can actually be explained, but not today. When it comes to copyright, because we look at life through a digital lens, you increasingly, you just have to understand that copyright kicks in as soon as there is any kind of a recording, any kind of absolute structure or memorialization takes place. We call it fixation in law, and we call it fixation in copyright. I wouldn't get too hung up on the words. The fundamental problem is that when you look at the world, when you look at a sign, when you read a book, when you look at a piece of architecture through your eyes, there is no legal consequence as long as you're in the right place to do that. You know, you haven't trespassed or done something weird. However, if you look at the same image through a digital lens, there are very likely to be legal consequences. So that's one starting point here. A second starting point is just, Celine dealt with this, but just the power of the technology we're dealing with. This is a real picture, and if you put VR headsets on cows with various sorts of images that they find soothing, they will produce more milk. So you can see right away there's elements of manipulation, results-based manipulation, which obviously attracts, as Celine told us, the scrutiny of legislators and regulators, and there's also changed behaviors, which, you know, in an educational sense, gee, these things can be tools that make our students or help our students learn more. There's some, you know, fascinating issues. I'm not going to spend much time on this, but I've been living with this slide and have thought a lot over the last 5 years about, is there something fundamental in what's digital that exacerbates these problems, makes them worse, and makes them worse from a legal point of view? I believe there is. We don't actually have the time for me to get into that, but I invite you to think about digital differences. Now, I want to talk about kind of my definition of AI. And I sort of love this story because it can be taken both metaphorically and literally. It exists in both, which is a rare and wonderful thing. This is an AI camera. This AI camera does not have a lens. It doesn't work the way any camera, whether it's your 30-year-old DSLR with film or your new digital camera works. There's no lens at all. There's no light coming through, and there's no capture in that sense. What it does is wherever you are taking a photo or wish to take a photo, it aggregates all of the information available, whether it's through GPS, getting the GPS to look up photographs on the internet, or otherwise. It just basically sucks up all of the information about how your camera is positioned, where it is, and it consolidates from multiple sources through digital means, obviously. It composites a photograph of wherever you're pointing the camera. But again, there's no lens. There is just a giant digital network, a network of networks, as we know. So this is really a very different way of approaching the world. Is this really a camera, or is this something else? And it is that question of, is it something else, that in part creates the concerns that lead to legislation and regulation. On the other hand, from an educational standpoint, we go, well, gee, how could this be useful to our students? How could this be useful to learning? We embrace alternate perspectives. We embrace seeing things in new ways and generating them in new ways. So there's a fundamental issue there. Also, because we're in Canada, I am, I think, contractually obligated to refer to Marshall McLuhan at least once an academic year. So I will deal with that obligation now. McLuhan on tools, we become what we behold, we shape our tools, and then our tools shape us. So we will shape AI. The profound question is, how will AI shape us? Law and regulation notwithstanding. And for some of us, many, I suspect, who are in the community of practice, how will it shape our students? How will it shape their learning? And how can we make that better? We know that technology changes how we look and think about things. So let me deal with kind of the first big headline. I've got about 3 big headlines that I want to deal with, and they all are pedagogically oriented. The first is, and this is our big room at the Allard School of Law. So I'm doing a little bit of an ad here, and it's just downstairs. Is AI a tool or a source? When I look at various universities and various faculties, more than universities really, when I look at various faculties' policies around AI usage for students, many of them refer to generative AI as a tool. I will submit for your consideration that that's not quite right, and that what we're conflating is a previous generation of a couple of previous generations of emerging technologies that were useful to students, that worried us, starting with the Texas Instruments pocket calculator. Well, it wasn't really a pocket calculator, but the massive calculators that emerged in the 1970s that were going to end the academic pursuit of mathematics, because we'd never produce good mathematicians or physicists again, because they would never have to longhand do calculations and they would lose all their abilities. We now, of course, understand very well that that was complete nonsense, but that was going to end education at that time. And then many of you were around when search engines and Google, as it became very strong, was going to end education as we know it. Those are legitimately tools. Generative AI, however, I would argue is not a tool. It's a source. It is creating content. Whether that content attracts copyright or not, put that in a different basket. I'll talk about it as my next point. But the way I treat it in my classes and the way I believe we should treat it in academia is you have to cite it, and you're responsible both for whether it's good and whether it plagiarizes. Because if it's a bad source, you've cited a bad source, and you will be deducted for that. And if it plagiarizes, you've plagiarized. And I think a lot of problems are dealt with by understanding AI for what generative AI for what I believe it is, and that is a source, not a tool. So I've made my point there, and there is some legal tension around this, as I've mentioned, and this is copyright issues, Canadian Copyright Board, the U.S. Copyright Office, dealing with what is AI. And there's two levels of this in simple form. One is, can an AI own a copyright? U.S. Copyright Office said no. I have very little doubt that's equally true in Canada, and is the correct answer. But what about an AI image that you use to illustrate? The famous example before this one in the United States was somebody who wrote a comic book novel. I'm trying to remember what those are actually called. There's a name for it. You would all know what it is. But they were a really great writer, but they weren't a great illustrator. So they had the generative AI do the illustrations, which were fantastic for their writing. They submitted the work to the U.S. Copyright Office, and the Copyright Office said, absolutely, your words are copyrighted, but the images don't attract copyright because they were wholly generated by an AI. The further, I think, evolution of this is the more human interaction there is with the generative AI to create the image or create the work, the more likely it will be seen as copyright to the human who was involved in the creation. We don't yet know, we cannot yet tell you where that line is. The courts and the various administrative bodies will, over the next year or two, grapple with these issues more and more. The courts, to the extent we have them, you'll see this is from August 18th, so very recent U.S. court. So far, the very small sample, we have the courts following along with where the U.S. Copyright Office is leading them, and the Canadian practice and Copyright Board seem, from everything I've seen, to be leading in exactly the same directions. If it's wholly created by an AI, it's public domain and not copyrightable. I also tend to think this is the right decision, but I want you to sort of know. the further piece is that we are seeing various lawsuits. This is only one that are making their way through the courts that we do not have findings on by artists whose words or whose art are being used by the AIs for learning. So their work is some small part of somebody's output. I will predict that these lawsuits will succeed on a number of possible principles, fair use, fair dealing, but also quite possibly because when you work the numbers, they're what's called de minimis. They're so small that they don't actually, they wouldn't actually generate copyright. That said, it's a bit, we don't know, and the courts have surprised us. The last big thing that I want to talk about is very pedagogic. Sorry, I'm missing the second period after AI there. I'll fix that in the slide version I submit. And I call this How AI Should Teach Dancing. If you go on the internet, you will find that there are various tools that relate to dance, notation tools, and now we're starting to get some AI instructional tools, coaches, dance instructors, if you will. I picked dance because I'm a terrible dancer. I picked dance because I have, I certainly am not anymore. I was a long distance runner, a marathon runner. I don't have those high twitch muscles that give you the power to do real dance, ballet, or jazz. I used to have a lot of stamina, very little power. And we all have different bodies, and we all have different skill sets. And we're all very different, and we're very, very diverse. And our students are very, very diverse. And if you're interested in pedagogy, which I think everybody is, we know that our students don't learn the same way. I also am hoping that a number of the people who are here are going to be working with AI. And the key, I would argue, is that if you're going to teach me to dance, if you try and say, okay, Baryshnikov is the great dancer, and you, John Festinger, have to dance like Baryshnikov, and we're just going to keep breaking it down, I'm going to walk away, run away, not dance away very quickly. So really, the AI needs to inventory my body and realize what a mess I am, what my fitness levels are, get all the data in another way, and then create flexibility and maybe even alternate plans about sort of meet me on my terms, and slowly coax me and give me options so that I become Baryshnikov after about 200 years. That's a very different approach. And what's worrying about AI is right now, a lot of it is top down in terms of training. Here's the right way, and we'll just give you the lesson plans to get you to the right way. And there's not nearly enough diversity. So I'm going to talk in this regard. I'm going to give you some examples. I have in my courses, and I don't have time to talk about this, so I'll skip to the second one. But we at UBC with CTLT I've been working on a Socratic AI program that law students can use to have Socratic questions being asked of them by an AI on their own terms, not by their professor, about their subject. And it's not only for law, it looks like it can be for any faculty. And we're about to go public with that, I think, in the next 2 weeks. But the example that I hope is teed up to go is that Nikos Harris and I here at the law school, the most traumatizing part of first-year law school is something called the moot court, where law students, and many for the very first time, because I've never participated in debate club, for example, are arguing a case in front of 3 real lawyers, senior lawyers, sometimes even with an occasional judge thrown in. They're in first-year law school, and they're in a mock court of appeal, and they're arguing. Here, it's usually a criminal case, and it's terrifying, because they've never done it before, and it's what you fixate on and worry about for an entire semester, because you have the opportunity to get more and more nervous about it. And so we created a practice tool, and and it's actually been working for a while, and now we've introduced generative AI. And I want to show you how it works. The one thing I just want to footnote is that what you're about to see is truncated in time. It also was done by a tech person, not a lawyer, so you're not going to hear any legal argument and legal questions. You're just going to have to take my word for it. Certainly from Socrates, AI actually asks questions really, really well, much better than it answers them. And that's the subject of a different talk. And so what you're seeing is something that's edited for time, because it would take longer than this for the generative AI to work, not that much longer. And I'm going to throw it over to you guys to hopefully show this, and then I'll end.
Hello, esteemed court. My name is William Watkins. I am here to discuss the legal rights of dogs.
Good day, Mr. Watkins. Thank you for addressing this interesting topic. You may proceed with your argument regarding the legal rights of dogs. Can you please clarify your main point on this matter, so that we may delve deeper into it?
Dogs have not been recognized by the law to have personhood. I would like to appeal this decision as there is new evidence regarding the intelligence of dogs.
Thank you for your statement, Mr. Watkins. Your appeal seems to challenge the legal status of dogs as non-persons due to evolving understandings of their intelligence. To better understand your argument, could you provide some specific examples or evidence of this increased awareness of canine intelligence, and how you believe it should impact their legal standing?
I would like to address that, however, that is all the time I have to present today.
Thank you, Mr. Watkins, for your presentation on the legal rights of dogs. Your argument has certainly raised some intriguing questions. I appreciate your participation in this moot court session, and I wish you success in your further endeavors. Farewell, and have a great day.
Thank you, and have a good day as well.
So the last point I want to make, thank you for showing that. The last point I want to make is you can see that this is about the student doing it on their terms and using the AI to allow the student the freedom and the ability to practice. This is what I would argue is not sort of top-down AI, but actually something that can be used in pedagogy. The other thing, just to reiterate, those words, that script was not scripted. That came directly out of ChatGPT. So, in certain circumstances, generative AI is remarkably compelling. All that conversation was generated by the AI, not by us. So thank you. We can go to questions or any other kind of moderation at this point.
Absolutely. Thank you so much. We have 2 questions in the Q&A section. The first one is from Stamisha, and it says, have you seen any movement for governments to restructure their legislative processes to account for the speed in which AI and technology in general advances. I'm not a law student and have very limited knowledge of the processes of international governments, but there is recognition that some are meant to operate slowly on purpose. I don't have her exact words, but I believe Dr. Castet-Renard mentioned that if the upcoming draft of the EU AI Act does not account for certain aspects of AI, it will take time to update. As it is recognized that the law is lagging behind technology now, it is concerning that many things may fall within the cracks in the future. So yeah, this is for both of you. And then we'll get to Matt's question. Thank you. Oh,
No,
you're
you're
muted.
on mute.
I'll be quick and maybe set it up for Celine. I think it's an entirely valid concern. I think without an actual regulatory body that oversees, there are some challenges. The other thing I'll just mention that in Canada, a very interesting thing has happened where we now, in theory, lead the world. Canada, by dint of Bill C-11, the Online Streaming Act, has given the CRTC authority over the internet. We don't know how the CRTC, the Canadian Radio, Television and Telecommunications Commission, is going to oversee the internet, but AI is going to be an increasing and very prevalent part of the internet, and you could see the CRTC possibly, if something really bad was happening, asserting jurisdiction and regulating on a timely basis. I'm not willing to predict that. I'm just saying that there is a possibility that that could happen. And I'll turn it over to Celine.
This is an excellent question and one of the main challenges today regarding AI. And on the one hand, I think we still use the traditional tools for lawyers to try to create some frameworks such as law, such as regulation. But on the other hand, we also understand that we need to have something more agile, more flexible. And that's the reason why the Canadian government would like to have an agile approach. And that's the reason why we have Bill C-27, which with a lot of blanks and not much details, and also the companion document and the intention to create regulation, to add some regulation to give more flexibility. And this is the same with the EU. Even if we have a lot of details and a lot of some lists and a lot of use cases, very precise information, we also have the possibility for the European Commission for taking regulation as well. So we have similarities, and both legislators are very aware of this problem of speed technologies. And I would like to add also the technical standards. We didn't talk about that, but there is also standardization. ISO at the international level is the main actor here and the main player. And in Canada, we have the Canadian Council of Standardization as well. And in Europe, we also have some organism of standardization. This is another way to have a common framework at the international level, and maybe for having more flexibility, more operationalization of a legal framework, even if there are some limits. But this is another way to create norms, not only legal norms, but also technical norms.
Wonderful, thank you. All right, we have another question. The questions are starting to come in. People are definitely interested in this. And we realize there's a lot of complexity and that each of you are having to sort of gloss over at this point, right? But the next one is, what does it mean for an AI to wholly create an image or other work of art? This is as per the copyright discussion. there is a human-generated starting point, a prompt, a source image of some kind.
So
From that.
I'd like to address that at least as a starting point. The government of Canada has issued, and we certainly don't have the time. One of the courses I teach is administrative law. We certainly don't have time to go through the hows and whys of this. But the government of Canada, and I believe EU governments as well, or at least some of them, have said that any determination that is made, and this is just a policy right now, so it's not in legislation per se, any determination that is made entirely by an AI would be invalid from a governmental perspective. So, for example, if you handed over to an AI a parole board decision, please profile the person applying for parole and make a decision. And there's no human intervention in that decision. It's just, all of the odds and the algorithms mixed together. That is invalid. I agree. There's a human source for all of the information, all of the information that the AI learns from. But if you said to an AI, paint a painting, that, in my view, is wholly created by the AI, whatever they come up with. If you say paint a painting of a horse, is there enough human intervention to put that kind of in the human category? Now, if you're very specific, and I guess here's the copyright point. That doesn't mean this is all the points. An AI created a comic book based on a human script, and the copyright board in the United States, and seemingly the court, didn't feel that was enough to give the copyright protection to the human who asked the AI to do it. So these are, TBD, to be determined in the future, and we'll get decisions on them.
If I may, I would like to add that regarding copyright, the problem here is the author should be a human person, so that the reason why we have to determine the human part, and on the other hand, the ID is not protected. So it means the human has to have a huge or a sufficient intervention for the creation. And the prompt, there was a question regarding the prompt, and this is an interesting example. And I think the US copyright recognize the prompt. If there is a lot of details of the form and all the way the human would like to have the result, not something random. I think here there is a question of evidence, and you have to show all the information you made in your prompt and all the thing you ask to the systems. I would like to also mention that in the EU, we do not have broad exceptions such as fair use or fair dealing. We have only specific exceptions, a lot of details as usual. And we have an exception, a text and data mining exception with two different categories. One is for research and one is for commercial purpose. And regarding large language models and generative AI, we can consider we are in this situation of text and data mining for commercial purposes, and the use of works could be an exception. But in this case, there is an opt-out option for the author. They could ask to remove their works within the database. And this is currently a huge issue between the authors and the providers of LLMs.
Yes. Now, John has to go. Is that correct, John? Yeah. Okay.
That's right. Sorry about that.
That's okay.
My
We
students call.
understand. We
Take care.
appreciate you coming. So I'm just going to say a quick thank you to John for being here. And if Celine doesn't mind sticking around, we have one more question. To be honest.
Why not?
So it's in the Q&A,
Bye,
but thanks so much for being here, John. Okay, do you want me to read this one out? It's from Jeffrey in the Q&A.
Yes, please.
Okay. Jeffrey writes, it is my understanding that the United States, Mexico, Canada Free Trade Agreement brings the American Section 230 into Canadian law. Namely, platforms are not responsible for content hosted on their sites. Should we carve out AI-generated content, i.e. exclude AI-generated content from Section 230 protections?
That's also an interesting question, but I think concerning AI, we have both questions. One is about the generative AI, and another one is algorithmic moderation system. And regarding the AI generative AI, there is no matter if the content is generated by human or by machine, the rules are the same. Meaning Section 230 creates an exemption of liability, but there are also exceptions regarding porn, child pornography, for instance, and copyright. So it doesn't matter if it's generated by AI or by human. But this is the same regarding the system of content moderation. No, there is no difference if the content moderation has been made by a human or by a machine. So I don't see any impact of AI in this question for the moment.
Okay, wonderful. Oh, I see another question. Oh, it's still the same one. Okay. Question for you. Do you want to present the other portion that you had?
Very
it could be
quickly.
included in the it'd be nice to have it in the recording.
Yeah.
So for those who can stick around to watch, I'll let you introduce what you're going to do here.
Okay, very quickly. Yes, just to continue the conversation about generative AI, John mentioned some problems regarding some class action. I would like to mention another one regarding copyright on computer code. There is one on GitHub Copilot because a lot of computer scientists contribute with based on copyleft and open source license or GPL license, and the requirements of the license are not respected in case of their code is reproduced within generative AI. And there is also here a copyright problem and problems of contamination. So I would like to add this point, and maybe just to mention the fact that in the AI Act, in the EU framework, as I mentioned, the first version has been released in 2021, but now the text has been modified by the Council and the European Parliament. And even if the first version didn't include the generative AI and large language models, now we have some provisions because ChatGPT is entered into the market in November 2022. And the European legislator has been changed and has adapted its text, and it shows the problem of agility, flexibility of the law when there is a speed technology we previously mentioned. This problem we previously mentioned. And just to give you a quick overview, there are definitions on the foundational models and generative AI, and some specific rules. As I said, a lot of details, but just to give you a broad information of that, generative AI has to be specifically has to fulfill some specific requirements and is specifically regulated, and they will have some specific obligation to release a technical documentation, to reduce energy use, to have a certain quality of the database, the data set used, and so on. And this one is the most interesting, I think, regarding copyright problem. And this one is also a main issue currently, because the AI Act, a new article 28, imposed to the providers of generative AI integrated copyrighted materials to have a summary, to provide a summary of the use of training data protected under copyright law. And of course, it will be very difficult to fulfill this obligation because the traceability of the data used within the data sets useful for and used to train generative AI is almost impossible. Is probably impossible. So maybe that because of this kind of obligation, maybe the habits and the use, maybe the providers of generative AI will change their way of making their data sets, but for the moment, I'm sure they're not able to respect this obligation. I just want to stop here.
Okay, thank you so much. Yeah, last call for questions. We're going to do wrap up here, and I want to just quickly mention before I forget that the edited video of this will be available. Those of you who signed up should be getting a notification via email when it's ready. If you do not receive that within the next week, please just check back on the EMCoP website, because that's where this one will be posted. And we also have all the previous sessions posted there, especially over the past year. So I don't see any other questions coming in. So thank you to our presenters. No problem filling the hour and a half. And a thank you to all the UBC staff who work behind the scenes to make this happen. Our next session is tentatively going to be November 10th. We just need to confirm that, and you can sign up on the EMCoP website there as well to receive notifications. So thanks again to Dr. Castet-Renard and to John Festinger, and we're sorry that not everyone could be here today, but we'll wrap it up there. And there's in the chat just before you go, there's more information on how the websites that you can access the EML and the EMCoP. And once again, look up our presenters, take a look at their publications, and we look forward to seeing you all next time. Thank you very much.
Thank you so much. Bye.